Okay, hello everyone. We'll get started because we've reached noon. So welcome everyone. My name is Sharia Ali. I am the SLP advisor at ACSLPA. Today I'll be taking some time to discuss the college's revised informed consent for service guideline. You may be aware that this guideline was revised and is made available, the newest edition made available to members in August of this year. So some quick housekeeping notes for those of you who aren't frequent flyers on ACSLPA webinars. Your video and mic are turned off and they'll stay off for the duration of the webinar. It's just easier for us to manage on our end this way. The chat is available to you, so please feel free to put your questions, comments in there as we go along. I have time for questions at the end, but I do try to monitor the chat as we're moving through the slides. So I may stop and answer questions where I can. If I don't answer your question straight away, it's because I want to save it to the end or because I think there'll be a slide coming up that might answer your question. This presentation will be recorded and the slides and recording will be made available on ACSLPA's website in about a week's time. Also in red on the screen are helplines if you're having any technical issues and you need some help troubleshooting. Feel free to get in touch with us, phone number or email, or if the chat's available to you, you can put your troubles in there too. I am also going to ask Mackenzie to put a link to the webinar, to the guideline in the chat, and I see that it's there now. So you can follow along if you want to, and we'll jump right in. So you may have noticed, I hope you did, because I'm an SLP, there was a bit of a WH questions theme to the guideline. So I thought I'd keep it going with our agenda. So we're quickly going to run through those first two questions, why we revised the guideline and how it was revised. And we'll spend most of the time on looking at what the guideline actually says, or point out some key concepts or points that members should be aware of. So while most of the information in the guideline hasn't changed, it was due for a little refresh just because it was getting up in age for an ACSLPA document. The last review was in 2016. We do typically try to refresh our documents every so often just because we want to make sure everything's current for members. We don't want you to have to reference a guidance and practice guidance from 2010 or something. We try to keep it current. Also, I think probably the driving force behind this revision is that we identified a real gap in practice guidance that we wanted to address. I get a lot of questions as the SLP advisor around informed consent for minors in care, like foster care, or in family systems where there's separation or divorce dynamics. So we thought it would be a good idea just to make that information publicly available, more widely available to members in this guideline that's on our website so that you don't have to take time out of your day to call us to find answers when it's available to everyone. Also, just minor note, try to group the information under headings, and it's generally been reformatted for readability so that it's easier to find information if you're just skimming to find one piece of practice guidance. And really the underlying reason we want to make sure you have current and complete guidance is because informed consent is a foundation of ethical practice. There can actually be harmful implications for the client and serious implications for regulated members when informed consent is not handled appropriately. So if we look at the 4 bioethical principles that form the foundation of ACSLPA's Code of Ethics, that's on the right of the slide, we can see that informed consent is really tied to all of them. And informed consent is really recognizing that the client is the one who has the most to lose or gain from any services offered to them. That's obviously linked to autonomy or the client's right to make decisions about their own care. But when we also think about beneficence, which is acting in ways that benefit the health and well-being of the client, and also non-maleficence, practicing with the intent to do no harm or to minimize harm, the person who really defines what's beneficial or what's harmful to the client has to be the client. These things have to be defined from the client perspective. We can't decide for them because we don't live their lives, we don't have their perspective. And that also ties into the principle of justice, that all clients seeking care should have the agency to make decisions for themselves. So as we talk about informed consent today, I encourage you to think about to not just think about getting a client or a caregiver to sign a form or say yes, but shifting your perspective towards client autonomy and collaboration with the client in their care. Also, just a reminder that obtaining informed consent is a minimum requirement of practice for SLPs and audiologists, and the college has a standard of practice dedicated to informed consent. And maybe I'll just open that up now so you can see what it looks like. So these are the indicators there. With these standards of practice, with all standards of practice, not meeting minimum requirements, as outlined here, can be considered unprofessional conduct under the Health Professions Act. So you'll see that these indicators, they're actually pretty short, they're very brisk, matter-of-fact language. So the guideline provides more detail and context to assist with interpretation of these minimum requirements. So this graphic shows how the guideline was revised, and because we did a couple of things just differently this time, I wanted to just point out a couple of things. Also, I think it gives a nice little sneak peek into how the college does some of the work that it does. So the first is, let me get my laser pointer here. Typically, when the college is revising a guideline, we get together an ad hoc committee of regulated members who draft the revisions. We did not do that in this case, just because we already had a pretty good idea of the practice guidance needs in this area, and we felt that it could be more efficiently addressed using a development process where staff drafted the guidelines. After drafting, you may remember the guideline went out for member review and vetting. In this case, the feedback that we got helped us to get multiple perspectives across practice settings, and it helped us to really refine some of the practice guidance that we're giving in this guideline. Now, I just want to say that we do read every piece of feedback that we get, and we try to incorporate your perspectives into the work of the college. So please, if you have time, review the things that we send out for feedback, complete the surveys, contact us with any questions or concerns. Our work really has to be guided by the realities of your practice environments, so take those opportunities to provide feedback. And with that, I just want to bring two items to your attention really quickly. The first is that the college's updated guideline on the assessment of linguistically diverse clients will arrive in your inboxes pretty soon, before the end of September, I think I can confidently say. So if you're able to, please review that guideline, what we've drafted, and fill out the survey with your comments and suggestions. The second is that the member forum, ACSLPA's member forum, is on October 2nd. This is officially billed as an event to learn, connect, and share ideas with your college and other regulated members. It's free and it takes place virtually, and a link to register has already been emailed out to all members. One last thing to note here, I think this is probably the most important note for me, is that we did something we typically don't do with guidelines, which is get legal counsel review. In sort of drafting the revisions, I noticed there's just so much nuance in the legislation on informed consent. So I just wanted to feel really confident that the practice guidance that we're giving, it was vetted by an actual lawyer, so you can feel confident in that too. And finally, the finalized guideline was revised in June 2023. So let's start looking more in depth at the key concepts in the guideline. Like I mentioned, not much has changed in terms of content, so I won't be going into too much detail, but I want to cover the major points. So, firstly, around who can provide consent. Hopefully, you are all aware that under Alberta law, only the client or an authorized representative can provide consent for services. Now, there's a caveat that the person providing consent must have the competency to do so. We'll talk more about competency for consent a bit later on in the presentation. There's a whole slide on it. What's new in this section is that we expand a bit on the involvement of others in care and in assisting with decision-making. Now, based on family dynamics, cultural background, etc., a client may wish to have others involved in their care, and in particular to help with the emotional and mental load of processing information and making decisions about their health and well-being. So in these situations, the guidance is to respect the client's wishes, of course, And only where consent is given, share information with any others that the client wants involved in their care, so that these folks can assist the client in making an informed decision. So just to detour from that last slide on who can provide consent, like I said, questions around family dynamics where caregivers are separated or divorced is probably the most common inquiry I get as SLP advisor. So I wanted to have some more information on this. And we provided some guidance on this specifically in the clinical scenario section of the guideline, which is on pages 10 to 11. So the guidance on this, and this is in situations where parents share custody or they share decision-making authority. Typical guidance is that either parent can consent to services. Now, this is a substantial change from guidance we've given in the past, where we've typically recommended that the best practice would be to get consent from both parents wherever that's practical. However, this is where the review from legal counsel came in really handy. Their thought was that we don't want to infringe unnecessarily on parental rights of what the parent who initiated therapy, and that also we want to make our practice guidance as practical as possible for members. We also, in terms of fairness and equity, want to keep our guidance consistent for what we do for families where the parents are not separated. Typically, when one parent consents to services, in those cases, we assume that both parents consent. So we don't want to have one set of rules for one kind of family and put barriers in place for another kind of family. Our legal counsel also advised that this advice is what they've given to other organizations and colleges, so we're consistent with other bodies here. However, if you get even a whiff of a disagreement about services from between separated or divorced parents, best practice would be to make sure you get consent from both parents, if custody is shared, of course. And if a parent withdraws or refuses consent, you must cease services until parents can come to an agreement. Now, we acknowledge that this can be a very difficult position to be in as a professional. However, just a reminder, it's not your role to get a parent on side with therapy or to solve a dispute. It's your job to provide all the necessary information that would allow both parents or caregivers to make informed decisions about their child's care. You can, of course, encourage them to come to a consensus, but mediation is not a job for an SLP or an audiologist. That's a job for another kind of trained professional. So if you are caught up in custody cases, there may be a clinical scenario in Appendix C of the guideline that can help. The college also has some professional predicaments, and I'll take you to where you can find those on the website now. And I'm just seeing in the chat that someone's having trouble with the audio. So we'll go to professional predicaments and maybe we'll work behind the scenes to see if that is an issue. So I just wanted to share our professional predicament series with you all, because I think maybe not a lot of people are aware of this resource for practice guidance, because they're not typically housed with our standards of practice and our guidelines, but we do have lots of different professional predicaments. These are usually based on questions that we get a lot or just areas where we know there's some practice guidance gaps. So you can check them out. They're under members and communications and professional predicaments. So if you're looking for some practice guidance, for sure, check the standards of practice, our guidelines, but this might also be a good place for information as well. Okay, just getting some confirmation from the chat that audio seems to be all good on our end, so I hope everyone can hear me. Yeah, and just when you're caught up in custody cases as well, your SLP or audiology advisor is also a very good resource. I also just want to mention here that the law is really centered on nuclear family dynamics. So 2 parents, caregivers, 2.5 kids. It can get really tricky knowing what to do regarding consent for families who exist outside of this norm. For example, family systems where children are looked after by relatives just as needed, but there's no formal agreement that's ever in place. Or when families don't want to be involved with children's services or with the government because of past harm. So that limited scope in the legislation limits the guidance that ACSLPA can give in these situations in something like a guideline, because we have to be consistent with the legislation. So we can't cover every nuance. But please call in if you have a situation that's not addressed in the guideline or in a standards of practice. We can discuss and try to find a way forward that's in the best interest of the client. So when should consent be obtained? This should be prior to providing any professional services, including those listed on this slide here. And even when you have initial consent, you'll need to update that consent whenever there's a substantial change in the plan of care or when there's a change in diagnosis, symptoms, circumstance. Clients must also consent before care is assigned to someone, like a support personnel, or before a student or volunteer can be present during service provision. So let's take another quick little detour to discuss another question I get a lot around when consent should be obtained. And it's mostly from folks who work in classrooms, and when we're talking about universal classroom strategies versus targeted services with one particular student. The rule here, I guess we can call it, is that whenever any individualized services that are specific to a client is required, that informed consent must be obtained. So if you are providing general strategies to support communication in the classroom, that general classroom consent should suffice. However, like for example, if you're working with a teacher to implement a visual schedule for the whole class to transition throughout the day. However, if the teacher notes that there's a specific child that might benefit from individualized observation and strategies, then you must get consent before those services are provided. So if you can put a specific name or face to the assessment or intervention, then you need consent. So in terms of who is responsible for obtaining consent, this should be the professional who is most responsible for services provided. This person will be the best person to provide all the relevant information and to answer any questions from the client. Now, in this guideline, we clarify that certain aspects of the process of obtaining consent may be assigned to others, like the distribution and collection of forms. However, regulated members are still required to ensure that the consent is valid and informed. For example, by developing the information that's shared with clients on the services and being available to answer any questions from the clients. So another quick detail to talk about another situation that we get a lot of questions about, and that's around consent requirements for screenings and mass screenings. Consistent with what I've said in the last few slides, our practice guidance here is, of course, consent is required. You're screening a particular client. We know it might not be practical for members to contact each client or each caregiver to get consent themselves. So in this situation, the use of an information sheet and a consent form that clients or guardians can sign could be an appropriate route, but of course there are a few considerations. First is that the regulated member should be involved in developing the information that's shared that goes out to families or clients. And of course, you need to be available for discussion as needed. So other folks can help with the distribution and collection of consent forms, but the information that goes out is the domain of the professional that's ultimately accountable for services. Also note that the absence of a response, either way, yes or no, does not equal consent. So a few considerations when we think about how consent must be obtained. The primary one is that consent should be given voluntarily, free of coercion or intentional misrepresentation. Now, the stereotypical process is that the goal is that a form is signed, but really informed consent is not a one-time event. It's a collaborative, interactive, two-way process, ongoing process that leaves room for further discussion as necessary. Also, members must satisfy themselves that clients have the competency to make decisions about their care. And again, we'll talk about competency in a couple of slides. The process, the informed consent process, may have various communication modes, example face-to-face, by telephone or email. Consent can be expressed or implied. For example, if a client keeps showing up, we can assume that they consent to services. Consent can also be verbal or written. If it's verbal, be sure to document this. So informed consent should cover what's shown on the slide, and these are all listed on page 3 of the guideline. So finally, we get to the competency for consent slide. Now, in this guideline, we say that it's the responsibility of the professional to make a reasonable judgment of the client's competency to give consent. That's your first step. You want to make sure that the client is able to understand the subject matter related to decisions that have to be made, and that they're able to appreciate the consequences of making that decision. Now, this determination should be based on the information that's available to you at the time. Now, members must presume competency for decision-making until it can be proven otherwise. So the next step, if there are concerns, it's the responsibility of a regulated member to request a capacity assessment that's conducted by a trained and authorized capacity assessor. Now, when it's determined that the client lacks competency for decision-making, an alternate decision-maker must give consent. That can be a family member, a legal designate, or even the court. Now, the third step to all of this, and an underlying consideration, is that competency to provide informed consent can change over time and with respect to the type of services proposed. So, of course, you want to monitor for that over time. So we are actually almost finished with the formal part of the presentation. So I'll quickly discuss mature minors and consent. Now, typically, anyone under 18 is considered a minor in Alberta, and informed consent should be obtained from a parent or a guardian. However, we recognize that as minors age, they develop greater abilities to make independent decisions about their bodies, their health, their well-being. So in recognition of this, clients who are deemed mature minors are entitled to give or refuse consent for services, which then cannot be overridden by an adult guardian. Now, there is no age minimum when a minor can be considered mature. That determination is based on a variety of considerations that are shown on the right, and these are all listed in the guideline as well. So when you have to make this determination, the decision to consider a client a mature minor should be made prior to service provision, and the rationale and the decision should be clearly documented. So just some final thoughts as we wrap up on informed consent. While there are minimum requirements that must be met at all times, regardless of the practice setting, as per standards of practice, you'll notice in this guideline that there are some places where there's some latitude for professionals to use their judgment in their practice. For example, when we talk about concerns about decision-making competency, this guideline doesn't give a listing of all the indicators that would spell out if there were competency concerns. In situations like these, you have to apply your professional judgment of the client, the information presented, etc., to make that determination of whether to request a competency assessment. Now, every client, every situation is different, so the college can't be overly prescriptive or try to address every possible situation in a guideline or in any other practice document. We do trust that you will apply your professional decision-making skills prudently, reasonably, and justifiably. So just another final talking point as well on navigating informed consent and employer policy. And this can really be applied to any practice area, not just informed consent. We know that some agencies have robust policies on consent that are also consistent with the relevant legislation, and they can hold up against the legislation. When this is the case, employer policy can actually be a real resource for members. So if you have questions, make sure you also check and follow your employer policy. Now, we also know that some organizations have not so robust policies or guidance. Typically, their policy is call your college, which is not wrong guidance at all. It's what you need to be doing if you have questions. In this case, even if your employer is lax on consent requirements, it's still the responsibility of a regulated member to ensure standards of practice are met. So a regulated member can't say, well, my employer didn't tell me I had to do this. We don't have a policy for this. I wasn't required by my employer to do certain things. That won't hold up against the relevant legislation. So if you do have questions, contact ACSLPA. So I'm just seeing a question in chat. I'm going to wait till the end for that one because we're almost finished. And finally, just a reminder, everything relevant to informed consent should be clearly documented in the client file in a timely manner. So I haven't seen any other questions come in, so maybe we will call it quits there. Thanks again, everyone, for attending, taking time out of your busy day. And don't forget, you can always follow up with me if you have any questions at the email shown.